Massey 2009 schedule of events on demand.
The Supreme Court will hear an interesting case Tuesday that centers on West Virginia's top judge who refused to step down from a $50 million lawsuit. Shannon Bream joins us with more. Shannon.
Well, Chris, Brent Benjamin was elected to the West Virginia Supreme Court back in 2004. He's come under fire over his refusal to recuse himself from a trial involving coal company CEO Don Blankenship, a man who spent millions of dollars on advertisements for Benjamin's campaign.
So help me God. Congratulations. Thank you.
West Virginia Supreme Court Chief Justice Brent Benjamin is like many state-level judges. Before he can don a black robe and pose with family for a ceremonial picture, he must first put himself before the voters. In 2004, Benjamin, a lawyer from Charleston, won his seat to the state's highest court, but not without the massive financial support of this man. Don Blankenship, a coal executive who thought Benjamin might be a more friendly voice in cases involving his company, one of the largest in the state. Blankenship spent $3 million in ads to help put Benjamin on the bench, all perfectly legal. But where the story gets tricky is that when the time came, Justice Benjamin refused to recuse himself from a $50 million case involving Blankenship's coal company. Sure enough, Benjamin's vote proved to be the difference. The losing side says its due process rights were violated by Benjamin's decision to hear the case. Benjamin says there was no reason to recuse himself because there is no conflict of interest. This case also brings to light the concerns some have about electing judges, including the disproportionate influence that one man with a lot of money can have in determining who wins a seat to a state Supreme Court. And joining us now to discuss this case is Ronald Rotunda of the Chapman University School of Law and Elizabeth Wydra of the Constitutional Accountability Center. Mr. Rotunda, I'll start with you. You've written extensively on judicial ethics. You don't see a problem here. Why not?
Well, the facts are a lot more attenuated. That is, we have a situation where neither the company nor the lawyer for the company gave any money to Benjamin or his opponent. I think an affiliate of the company gave $1,000, the maximum under West Virginia law. But Mr. Blankenship, who owns 0.35% of the company, gave several $1 million to defeat McGraw, the judge running against Benjamin, and mainly on grounds of medical malpractice decisions. So it's kind of really very attenuated, and so they end up having the plaintiffs arguing the judge should disqualify himself because he might have a debt of gratitude to this person who he does not know, who has a very minor financial interest in the case, and who basically was opposing his opponent for various reasons, typically medical malpractice. So their theory is that there's a debt of gratitude that you might have for someone, and the problem with the theory is it ends up disqualifying a lot of judges. For example, you would think that Ginsburg and Breyer would have a debt of gratitude to Clinton, who put them on the Supreme Court, yet they decided Jones v. Clinton, against Clinton, by the way, just like in this case, Benjamin decided, I think, 5 or 6 cases against Massey, and in this one, he decided, I guess, in favor of Massey. But the
let me check in now with Ms. Wydra and get her opinion. Obviously, you're going to be on the other side of this, and you've written extensively about this case as well. Some are going to argue this is a states' right issue. Nobody should be telling the states how they run their elections or how they choose a chief justice. What's your take on that?
Shannon, I'd like to bring it back to some first principles for a moment. Our Constitution's text and history requires that every state in America, whether it elects its judges or appoints them, has a fair system of justice that we can all believe in. And that's simply not possible if Mr. Blankenship can buy his judge's way into office. Look, the facts here are disturbing but clear. Mr. Blankenship spent millions of dollars, 60% of the total amount spent in support of Justice Benjamin's candidacy, and that certainly creates the appearance, if not the reality, of an unconstitutional pay-to-play justice system.
All right, Ronald Rotunda and Elizabeth Wydra, thank you so much for joining this debate today. We will now leave it to our 9 justices of the U.S. Supreme Court who will tackle this on Tuesday. Thank you both. Chris, back to you.
Shannon, thank you. On the campaign trail, President Obama said the government couldn't afford to wait for the economy to recover before reforming the health care system. We'll talk with our insiders about the speed and reach of Mr. Obama's agenda next.